A 15-year-old boy makes a crank phone call, a stupid juvenile prank, a few crude remarks to a neighbor. For that, he is taken from his home, given no lawyer, never allowed to face the person accusing him, and locked away for up to 6 years. An adult who did the exact same thing would have faced at most a small fine and 2 months. So how could a 15-year-old get 6 years? Because in 1964, a child standing in an American courtroom had almost no rights at all. This is the story of Gerald Gault, the case that finally carried the Constitution through the door of the juvenile court and rewrote what rights a child has when the state comes for their freedom. One note before we begin: this is legal history and education, not legal advice. To understand it, you have to understand the juvenile court itself. It was invented around the year 1900 with genuinely good intentions. The idea was that children who got into trouble shouldn't be treated as criminals. Instead of a harsh adversarial trial, a juvenile court would be gentle, private, informal. A wise judge acting almost like a parent, deciding what was best for the child. No prosecutors, no defense lawyers, no rigid rules. But that very informality hid a danger. Now to the case. June 1964, Gila County, Arizona. A 15-year-old named Gerald Gault and a friend were accused of making a phone call to a neighbor, a Mrs. Cook. A call filled with the crude, adolescent remarks teenage boys sometimes think are funny. Mrs. Cook complained to the police, and that complaint set everything in motion. The sheriff took Gerald into custody. But here is the first thing that should stop you. His parents were at work, and no one told them. His mother came home to an empty house and no son. She had to send his older brother out searching, and only later learned that Gerald was being held at the county detention home. When she got there, she was not allowed to take him back. It's worth knowing one more thing. Gerald was already on probation from a few months earlier for having been in the company of another boy who had taken a woman's wallet. He hadn't taken it himself. He was just there. But in the eyes of the system, he was now a known quantity, a kid already in the file, and that shaped everything that came next. The next day came the first hearing. It was held informally in the judge's chambers. And look at who was missing. Mrs. Cook, the woman making the accusation, was not there. Not that day, not ever. No one was placed under oath. No transcript or recording was made. There was no lawyer for Gerald. He was simply questioned by the judge. And to this day, the people in that room disagreed about what he actually admitted. At the end, the judge said he would think about it. Gerald was sent back to the detention home, held for several more days, then released with no explanation at all. Soon after, his mother received a note, handwritten on plain paper, telling the family that another hearing had been set. That note was their only notice. At the second hearing, it happened again. The accuser still wasn't there. Gerald's mother actually asked that Mrs. Cook be present so she could say which boy had done the talking. The judge answered that she didn't need to be there. Once again, no oath, no record, just the word of a probation officer in the judge's own impression. And then the judge delivered his decision. He declared Gerald a delinquent child and committed him to the state industrial school for the period of his minority, meaning until he turned 21. Gerald was 15. That sentence was, in plain terms, up to 6 years of confinement. Now here's the fact that stops people cold. For that same offense, the crude phone call, an adult in Arizona faced a maximum of 2 months in jail and a fine of $50. 2 months. Gerald, because he was 15, was given up to 6 years. The child received the far harsher punishment and got there with almost none of the protections an adult would have had. How was that even possible? Because in the eyes of the law, juvenile court was not criminal. In theory, it wasn't punishing Gerald, it was helping him. And because it was framed as help rather than punishment, the reasoning went, a child didn't need the rights an adult would get. No formal notice of charges, no lawyer, no chance to confront the accuser, no protection against being made to incriminate himself. All of it waved away as being in the child's own best interest. But look at what help actually meant here. It meant a locked institution for years cut off from his family. The label on the door said care. The reality behind it was incarceration, and the good intentions of the system had quietly stripped a boy of nearly every protection the Constitution was supposed to guarantee. The kindness was real. So was the cage. Gerald's parents refused to accept it. They filed a petition for a writ of habeas corpus, an ancient legal tool that demands the government justify holding someone. Arizona's courts turned them down at every level, so they carried the fight all the way to the Supreme Court of the United States. And the question they put before it was simple and enormous. Does the Constitution's promise of due process follow a child through the door of a juvenile court? In 1967, the court gave its answer. By a vote of 8-1, it sided with Gerald. And writing for the majority was a name we have met before in this series, Justice Abe Fortas. The very same justice who, just 2 years later, would write the great student speech decision, Tinker. Fortas believed deeply that young people are persons under the Constitution, and here he said so in words no one forgets. Under our Constitution, he wrote, the condition of being a boy does not justify a kangaroo court. Good intentions, the court held, are not enough. A juvenile court can be caring, it can be informal, but when it has the power to take away a child's liberty for years, it must first give that child real, fair process. Kindness is not a substitute for justice. So the court laid out what a young person must be given in any delinquency case that could lead to confinement. First, proper written notice of the specific charges. Second, the right to a lawyer, appointed by the state if the family cannot afford one. Third, the right to confront and cross-examine the witnesses against them. And fourth, the right to remain silent, the privilege against being forced to incriminate yourself. And notice what those 4 rights actually are. The lawyer, that is the promise of Gideon, the right to counsel, the right to remain silent. That is the heart of Miranda, decided just 1 year before. What the court had spent the decade building for accused adults, Gault reached out and extended to children, the same shield now held over the young. Because a child's freedom is every bit as real as an adult's. A locked door does not feel less locked because you are 15, and the court's logic was blunt. If the state intends to take years of a young person's life, it has to prove its case. Out in the open, under oath, with the child able to see the accuser, answer the charge, and defend himself. Anything less is not care, it is just power. One justice disagreed, and his warning deserves to be heard. Justice Potter Stewart, the lone dissenter, argued that juvenile court was never meant to be a criminal trial. Its whole purpose was to rescue and rehabilitate children, quietly and humanely, not to prosecute them. Pile on the formal, adversarial machinery of an adult courtroom, he cautioned, and you might destroy the very gentleness that made juvenile court worth having. It is a genuine tension. Protection on one side, fair process on the other, and it never fully goes away. But the majority held, and the effect was profound. After Gault, the Constitution followed children into the juvenile courtroom. The near unlimited discretion of a juvenile judge now had firm limits. A young person accused of an offense had a written charge, a lawyer at their side, an accuser they could face, and the right to stay silent. The private, informal room had become, at last, a court of law. And that is still the world we live in. Every time a young person in a delinquency case is told they have the right to a lawyer, is handed the charges in writing, is allowed to challenge the evidence against them, that is Gault at work. It is the reason a juvenile courtroom today looks like a place bound by law, and not like one adult's unchecked judgment about a child's fate. Step back and see the whole shape of it. We have watched the Constitution show up for adults. In a police station, in Miranda, in a prison cell, in Gideon, at the front door of a home, in MAP. And we have watched it show up for the young, in a school hallway, in Tinker. Gault is the case where those two streams meet. It is the ruling that said the Bill of Rights is not something you finally earn on your 18th birthday. A frightened 15-year-old has it too. And Gerald Gault himself? A foolish phone call cost him his freedom as a boy. But his family's refusal to accept that injustice ended up rewriting the rights of every young person in America. Years later, he pointed out something haunting. He never once saw the woman who accused him. She never had to appear at all. The case that now carries his name made certain that no child would ever again be judged that way, unseen, unheard, and unrepresented. So the next time you assume the Constitution is really for grown-ups, for the accused adult, the voter, the citizen, remember a 15-year-old boy in Arizona, a stupid phone call, and 6 years handed down by a court that never had to prove a single thing. The Supreme Court decided that the youngest and most powerless among us are owed the protection of the law most of all. If that is the kind of thing you want to understand more deeply, consider subscribing. We take one landmark case at a time, and we try to get it right. Thank you for watching, and remember, this video is for education and history. It is not legal advice.